Let's begin with neutrality. International arbitration provides a neutral forum for dispute resolution, detached from the parties, typically parties from different jurisdictions of different nationalities, and their own respective home governments, home states. In an ordinary international commercial dispute where the parties have concluded no dispute resolution agreement, each party will instinctively and often inevitably prefer that disputes be resolved on its own home turf. In a dispute between Russian and Chinese parties, the Russian party instinctively and inevitably will prefer dispute resolution in Russian courts, the Chinese party in Chinese courts, each for obvious reasons. Neither party will wish to litigate the dispute on its counterparty's home turf, where its counterparty enjoys advantages of language, culture, personal connections, relationships with outside counsel, and a host of other benefits. An agreement to arbitrate in a neutral forum prevents either party from having to litigate in its counterparty's home courts. Neither party may get its preferred alternative. If a Russian and Chinese party agree to arbitrate in, say, Singapore or London, neither party gets its preferred forum for dispute resolution. The Russian party doesn't get to litigate in Moscow, the Chinese party in Beijing. Instead, both parties avoid their least favored option. Both parties avoid having to litigate in their counterparty's backyard, and instead, each party gets its second favored alternative, namely a neutral, even-handed forum where neither party enjoys an advantage, where both parties will be treated equally. Empirical research confirms the importance of neutrality to businesses in international commerce. We can see, for example, a Queen Mary University of London study in 2013, which ranked neutrality almost at the top of the benefits provided by international commercial arbitration. Another study reached similar conclusions, neutrality being ranked high among the characteristics of international arbitration that attracted business users. It's important to emphasize the importance of neutrality and the lack of parochial bias in international dispute resolution. The burden of being required and the risk of being required to litigate a dispute in one's counterparty's home jurisdiction is substantial indeed. The Lowen versus United States investment arbitral award involved a Canadian business that was subjected to flagrantly parochial and biased judicial treatment in U.S. state courts. A neutral international investment tribunal concluded that the conduct of the trial by the U.S. trial judge in a state court was so flawed that it constituted a miscarriage of justice amounting to a manifest injustice, as that expression is understood in international law. Many state court proceedings in many jurisdictions around the world are no different. Foreign parties face, in many cases, naked parochial bias against them because they are foreign. Most commercial parties rightly have no desire to subject themselves to that sort of judicial treatment or mistreatment. In some circumstances, parties are exposed to even greater risks. NGOs, Transparency International, and others have studied the incidence of corruption in judicial proceedings around the world. One is more likely to encounter corruption in judicial proceedings than in almost any other type of governmental activity. Worldwide, 8%, nearly 10% of all respondents to a study by Transparency International in 2007 reported that they had paid a bribe in judicial proceedings. Bribery was particularly high in some jurisdictions where more than 1 in every 3 users admitted to paying a bribe. In other jurisdictions, the figures were somewhat smaller, but still shocking. 15% nearly 10% in other jurisdictions. Most international businesses cannot afford to, will not be permitted to engage in dispute resolution in a forum where justice is what you pay for. International arbitration offers a way to avoid this risk, to avoid the risk of official corruption, governmental bribe-taking, the payment of bribes to judges in return for their decisions, which is remarkably prevalent in many countries around the world. International arbitration also offers a mechanism for the centralized resolution of disputes. Absent a dispute resolution agreement, parties will often be faced with litigation in international transactions in multiple forums. If parties from, for example, the United States and France conclude a commercial contract but did not conclude any dispute resolution agreement, then they typically can anticipate multiple judicial proceedings, multiple litigations in the courts of different states, the United States and France at a minimum, perhaps others. Disputes will not be centralized in a single forum, and as a consequence, parties will be required to pay for multiple sets of lawyers in multiple different proceedings, producing, in all likelihood, inconsistent or contradictory decisions, both on jurisdictional, procedural, and ultimately substantive grounds. The United States Supreme Court, in a classic decision, Brayman versus Zapata Offshore Company, noted that much uncertainty and possibly great inconvenience to both parties could arise if a suit could be maintained in any jurisdiction where judicial jurisdiction could be established. The elimination of all such uncertainties by agreeing in advance on a forum, in the singular, acceptable to both parties, is an indispensable element in international trade, commerce, and contracting. That observation is precisely correct. The risks of international commerce, the legal risks, the commercial risks, are dramatically increased if the parties do not agree upon a single dispute resolution forum. The risk of multiple proceedings, the risk of inconsistent judgments is enormous. And as a consequence, parties agreed to resolve their disputes by international arbitration, centralizing their disputes in a single contractual forum. Relatedly, international arbitration offers an enforceability premium with respect to both international arbitration agreements on the one hand and international arbitral awards on the other hand. The New York Convention and national arbitration legislation establish, as we will see, a robust pro-enforcement legal framework for both international arbitration agreements and international arbitral awards. This enforceability premium puts international arbitration agreements in a preferred position vis-a-vis forum selection clauses on the one hand, and puts international arbitral awards in a preferred position as compared to national court judgments on the other hand. This enforceability premium ensures that when parties agree upon a means of dispute resolution, international arbitration, that agreement will be given effect, and that the results of the arbitration also will be given effect, as we will see, in 160 jurisdictions around the world. Historically, difficulties in enforcing domestic court judgments were substantial. During the Middle Ages, a leading scholar on medieval legal affairs and commerce observed that the difficulties in enforcing national court judgments inhibited international commerce, left parties despairing of knowing before which authority to bring their suits. And instead, parties, even then in the Middle Ages at the trade fairs, agreed upon arbitration as a means to resolve their disputes, choosing a single forum, arbitration, for the resolution of their disputes, because in part of the enforceability that it provided. The enforceability is enhanced materially in contemporary life. It's enhanced materially by virtue, most importantly, of the New York Convention, the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards. Article 2 of that convention, in Article 2, subparagraph 1, imposes on all 160 contracting states, an obligation, a mandatory international obligation to recognize international arbitration agreements. We can see the terms of Article 2 on the current slide, Article 2, subparagraph 1, which we will examine at length in subsequent chapters. Likewise, Article 2, subparagraph 3 of the Convention provides a specific mechanism for the enforcement of international arbitration agreements. It imposes another mandatory international rule requiring contracting states, the courts of contracting states, to refer parties to arbitration agreements to arbitration rather than hearing the merits of their disputes in state court litigation. These obligations, the obligations under Article 2, subparagraph 1 to recognize international arbitration agreements, the obligation under Article 2, subparagraph 3 to refer parties to arbitration, are subject only to limited and exhaustively specified exceptions. Absent one of these exceptions applying, states, all 160 contracting states, are obliged as a matter of mandatory international law to recognize and enforce international arbitration agreements. The same basic approach is adopted with respect to international arbitral awards issued at the end of the arbitral process. Articles 3 and 4 of the New York Convention require all contracting states, all 161 contracting states. Articles 3, 4, and 5 of the New York Convention adopt precisely the same approach with respect to international arbitral awards issued at the end of the arbitral process. Article 3, excerpted on the current slide, which we will examine in much greater detail in subsequent chapters, obliges all 160 contracting states to recognize foreign and non-domestic arbitral awards. Article 4 specifies an expedited and uncomplicated means of proving the existence of an arbitral award. And Article 5 lists a limited set of narrowly defined exceptions to this international obligation to recognize and enforce foreign arbitral awards. Those exceptions are narrowly drawn and are exhaustive. Contracting states cannot deny recognition of foreign or non-domestic arbitral awards save on one of the grounds specified in the New York Convention. Taken together, these provisions of the New York Convention, Article 2 for international arbitration agreements, Articles 3, 4, and 5 for foreign arbitral awards, ensure that both of these instruments, international arbitration agreements and arbitral awards, enjoy an enforceability premium. These instruments, arbitration agreements and arbitral awards, are maximally enforceable in all the contracting states to the New York Convention. The New York Convention is implemented by national arbitration legislation in all its contracting states. The UNCITRAL model law is a good example. It provides in Article 8 of the model law precisely what Article 2 of the New York Convention does, namely, state courts must recognize and enforce international arbitration agreements by referring parties to arbitration rather than permitting them to litigate in national courts, subject only to very limited and specifically defined exceptions. Article 35 of the UNCITRAL model law and Article 36 as well provide limited bases for denying recognition of arbitral awards and provide a rule of presumptive validity of arbitral awards, again, requiring courts to recognize and enforce those awards subject only to very limited, restrictively defined exceptions. Once again, international arbitration agreements and arbitral awards enjoy an enforceability premium as compared to either forum selection clauses, providing for disputes to be resolved in national courts, or national court judgments. In some parts of the world, there are regional arrangements that, broadly speaking, have similarities to the New York Convention. In Europe, the European Union, for example, the former Brussels Convention, later the Brussels Regulation recast, European Regulation 1215/2012, provides for the recognition of judicial jurisdiction by the courts of member states, provides for giving effect to form selection agreements and provides for the recognition of national court judgments all within the territory of the European Union. This ensures that both form selection agreements and national court judgments will enjoy enforceability, broadly speaking, comparable to that of arbitral awards and arbitration agreements under the New York Convention. This treaty, however, subsequently this regulation, is limited strictly to the European Union, and even within the European Union, differences in the enforcement of the regulation by national courts give rise to doubts as to the efficacy of its enforcement mechanisms. Outside the European Union, however, there are virtually no comparable instruments, and as a consequence, there is no international parallel to the New York Convention. Likewise, there are some industry-specific instruments in particular economic sectors, for example, air transport, where there are some rules regarding the allocation of judicial jurisdiction and, to some extent, recognition of national court judgments. These rules are, however, both very limited to specific sectors, such as the Warsaw Convention for the unification of certain rules relating to international carriage by air, and the enforcement mechanisms that they provide lack the potency, lack the robustness of the New York Convention. As a consequence, form selection agreements on the one hand and national court judgments on the other hand currently benefit from nothing remotely approaching the efficacy of the New York Convention. Some major states, including the United States, are party to no bilateral agreements regarding form selection clauses on the one hand, their validity and enforceability, or national court judgments, their recognition. Recognition of foreign court judgments and enforcement of form selection agreements is wholly a matter of domestic law. Many other major trading states also have no or no effective bilateral or multilateral treaty commitments regarding form selection clauses or foreign court judgments. There is some possibility that in the future the Hague Convention on Choice of Court Agreements will achieve broader ratification and support than it currently has today. Only three states are party to the Hague Choice of Court Agreements Convention, providing in broad terms for the enforcement of form selection agreements and resulting judgments. Thus far, however, very few states have acceded to the Hague Convention, and the possibility that it will represent an effective competitor to the New York Convention and national arbitration legislation is extremely remote. As a consequence, the recognition of international arbitration agreements and international arbitral awards is substantially more likely than the recognition and enforcement of form selection agreements and national court judgments. Put differently, international arbitration enjoys an enforceability premium, a very substantial enforceability premium as compared to other types of dispute resolution agreements and other types of decisions. When companies conclude international arbitration agreements, they do so with the knowledge that those agreements will be given effect under mandatory rules of international law, and the results produced by those agreements, arbitral awards, will also be recognized and enforced in accordance with binding mandatory rules of international law.